Okay, chapter 17 talks about how we're going to prepare our case for court. So first we want to review the facts of the case. What was the probable cause for the arrest? Did the correct criminal charge get filed? Are there any potential violations of constitutional rights? What's the possibility of conviction versus acquittal? Can each element of the crime be established beyond a reasonable doubt? And how credible are the witnesses and evidence? So first we're going to work on preparing our physical evidence. We want to be able to show that there was a strong chain of custody, okay? And this is something that's frequently attacked by defense counsel. Any break in the chain may make it inadmissible because it could mean that you can't guarantee that the evidence is the same as when it was collected. So generally, all evidence has been marked and signed for. You also want to make sure you understand the significance of each piece of evidence and understand its strengths and weaknesses. Prosecution often works closely with the police. For an indigent defendant, there is little independent investigation. So when we have a database of our evidence, right, each piece deserves a separate entry. It should have a description of the item, where it was obtained, what justifies its seizure, chain of custody, and the test performed. Each piece of physical evidence needs a witness to guide it into admission. So remember, for each piece of physical evidence, there is going to be a witness who is going to lay the foundation for its admission. We're going to have a complete list of witnesses as well. This is from both prosecution and defense. And you want to put everyone you might want to call, even though not everyone on the list may be called. You also want evidence each party on the list would give needs to be known. If possible, each witness should be deposed beforehand. This is a written or oral statement regarding what they will say in court. The presence of a witness can be compelled by a subpoena, and it also, remember, may be necessary to impeach a witness or for you to rehabilitate a witness of yours that has been impeached. So in advance, we want to look for any obvious problems with arrests, eyesight. Does the person have the motive to lie? A database on each witness should be constructed using the names and aliases, current address, any content of the testimony, and the strengths and weaknesses of each witness. Often witnesses and victims feel forgotten, so we should attempt to reduce any inconveniences that come along with testifying. Keep them informed of trial dates, speak with them before trial, in particular highlight any possible problems, and remember that memory may be a particular issue as trials generally happen much like after a year or possibly longer. Remember that witnesses may lack current memory and what they said earlier may be admissible, so we want to remember those exceptions to the hearsay rule. The statement would be admissible if made at trial. The current witness lacks accurate memory. There's a report made when the memory was fresh, a report made by the witness or under their direction, a report of a true statement, and a report that's authenticated. We also want to remember that the appearance really matters, so how a witness looks can be critical, and this is important for lay witnesses, police witnesses, and expert witnesses. How they speak is also important, so not just the content of what they're saying, but the method of their speech as well. So witnesses are often judged by externals as opposed to just what they're testifying to. So the jury's first impression is critical. Police should project a professional image, overall neat, clean, and appropriate. Uniforms are common, but not always best. Detectives frequently will appear in a suit. Avoid anything ostentatious. Your demeanor should be polite and proper. An officer should be an unbiased pursuer of the truth and not vindictive. Remember that opposing counsel is doing their job and it's not personal. We want to use good grammar, strong vocabulary, and really avoid jargon. We want to clearly understand the questions, not be arrogant, not appear as a quote-unquote professional witness, so avoid short-clipped speech, don't be hostile, and how you behave off the stand while waiting, testifying, and afterwards matters too. As far as the prosecution goes, don't become hostile if you don't openly, you don't want to become hostile if, a witness doesn't openly support the police position. You also want to discuss the case with prosecution before trial if necessary. You want to limit the contact with the defense, generally filter any contact with the defense for witnesses through the prosecution, and remain polite but not overly familiar. We want to treat witnesses with courtesy and respect and keep them informed. And the only contact with jurors should be at the trial while testifying. There should be no outside contact, and don't answer any questions outside court. Remember that the First Amendment guarantees freedom of the press, and so the media does have a right to cover trials, but when a juvenile is involved, they usually don't, or their right to cover it is very limited. Pre-trial publicity can harm the possibility of a conviction, and so gag orders are pretty rare, but they may be used to keep publicity in check. Most cases are only of minor interest to the media. If it is an important case, you should talk to your department about their guidelines and be courteous with the press. You also shouldn't try your case in the press, only give accurate statements, nothing inflammatory, and try to limit comments on confessions. And particularly avoid statements during trial. Few juries are actually sequestered, and while they're not supposed to be viewing the news or, viewing and consuming the news, they might be. So in Shepard v. Maxwell, Sam Shepard was accused of murdering his wife. And there was a lot of negative publicity about the case, some of it fueled by the prosecution and police. The conviction was overturned because of the, quote, carnival atmosphere at the trial. And at retrial, he was acquitted. And that wraps it up. Where's my recording?